Greetings and welcome to Motions, Law and Procedure from American Jurisprudence. Before we begin with the presentation, just to remind everyone, this is strictly for the entertainment and educational purposes of this broadcast and YouTube channel, not to be used, misconstrued, or abused for anything personal, private, business, law, legal, lawful, or financial or tax otherwise. So please don't do this at home. That said, let's get started. So we're going to be going over motions, the law and procedures. So how do we move the court? It's through motions, and we're going to learn everything you ever wanted to know about motions, but we're afraid to ask. Let's get started with our overview here. We're going to divide it into two sections so we can get through it quickly because it's a lot to cover. So it's going to be fast-paced, so hold on and pay attention, and you're going to learn a lot very quickly. We're going to go over the definition, the purpose, and the distinctions of motions, the scope, repetition, and joinder, and who may make a motion. Then we'll go over the motion procedure, the moving party's guide, starting with the form, filing, and timing, then the notice, service, and amendment, and finally we'll have some supporting papers and court considerations. Let's get going. Starting with the definition of a motion. A motion is a procedural request to a court for an order with an existing case. It's not a means to start a new litigation. The general definition is an application made to a court or judge to obtain a rule or order directing an act in the applicant's favor in a pending case. So there has to be an existing case. It's not used for starting a new case. It's used to move the court in the applicant's favor. The federal rules here is under the Federal Rules of Civil Procedure, a request for a court order must be made by motion. And the purpose is to bring a material but incidental matter arising during a case before the court, before a ruling. This is a procedural step within an action being a case for the court, not for new relief. A motion is not an appropriate vehicle for relief other than that sought in the underlying action or for raising distinct and independent matters. So it's not a way of adding to the relief here, essentially. That should be in the original petition. Supplement case here is a motion is defined as an application to the court for a ruling or an order in a pending case. And that's from Blazik versus Damon X, whatever. That's Connecticut 2nd District, 2010. All right, we're on to the observations and practice tips here for Section 1. The procedural formalities like notice of motion have distinct legal meanings, and courts have inherent powers to act for judicial efficiency. There's notice versus a motion. A notice of a motion is not itself a motion or petition, even if it states what will be presented. It's the court's initiative. A trial or appellate court may often act on its own initiative, sua sponte, spontaneously, essentially, in their own on their own initiative, in ways that a party could request by motion, provided no one is prejudiced. So the court can, on its own initiative, act in ways that a party normally would request by motion, but as long as no one's prejudiced, and I guess everyone agrees to it and consents or acquiesces, then the judge can act sua sponte and act in ways that a party normally would request by motion. Our observation here is a notice of motion, although it contains a statement of what motion will be presented, is not itself a motion or a petition. And our practice tip here is a trial or appellate court may ordinarily do on its own initiative what it may do on motion of a party, at least where the party benefited by the action is not likely to oppose or be prejudiced by it. So the court can't act sua sponte in one party's prejudice or bias towards one party. Should be judicial efficiency. All right, on to the next page. The distinction from pleadings and evidence. So now we'll look at the distinctions with the motions here. A motion is fundamentally different from a pleading and does not serve as evidence. It merely requests relief based on existing or future proof. So it requests relief and it's based on either the existing or what will be future proof. It's not a pleading. So here's our distinction. Motions are generally not considered pleadings. They ask for relief not included in the prayer of a pleading. And they're not evidence. Motions, whether sworn or not, are not evidence themselves. And there's a self-proving bar. A motion cannot prove itself. The allegations within it do not constitute proof of the fact stated. So it shouldn't be full of conclusory allegations. Practice tip. A motion cannot prove itself. Allegations and statements made in motions are not evidence. And allegations and motions do not amount to any proof of the fact stated. And our supplement case here is motions and arguments of counsel are not evidence. And that comes from Pennick versus the Most Worshipful Prince Hall Grand Lodge F&AM of Alabama Incorporated. And that was in 2010. Now we're on to the construction of a motion. Courts interpret motions based on their substance and intended relief, prioritizing justice over technical labels. There's a liberal interpretation. Courts may liberally interpret motions to be consistent with the best interest of justice, construing the motion as a whole. Let's see how this works. The liberal interpretations, which usually get shifty. Substance over form. The nature of a motion is determined by its essence, substance, or the relief sought, not by its title or label. And informing the adversary. The purpose of the procedural rules is to inform a party of the claims and relief sought by an adversary, simplifying litigation and avoiding technical roadblocks. So that's the construction of a motion. It should be looking at these factors here. Better to have it well worded than to leave it up to a liberal interpretation. The nature of the motion should be determined by its essence, substance, or the relief, not by its label, especially when a lot of these filings can be under just general labels. And informing the adversary. The whole purpose of the procedural rules of having to have a motion in the first place is to inform parties of claims and relief sought by an adversary This simplifies your litigation and avoids technical roadblocks like hearsay and such. The observation is the purpose of procedural rules governing motions is to inform a party of the nature of claims being asserted against him and the relief demanded by his adversary. Accordingly, motion provisions of procedural rules are construed to simplify litigation. Their objective is to avoid technical roadblocks and provide a speedy determination of litigation on the merits. So that's their objective, to provide a speedy determination of litigation on the merits. And we're on to the acceptance or hearing of a motion. A trial court has broad discretion to refuse to hear a motion that is repetitive or filed for an improper purpose. The court's discretion. Acceptance of a motion is generally within a trial court's sound discretion. Refusal to hear. A court may refuse to hear a motion that is repetitive or made for an improper purpose. And your improper purpose includes harassment causing unnecessary delay or needlessly increasing the cost of litigation. Oh boy. All right, and we shall proceed. Now we're on to what may be raised by a motion. Motions are tools to correct procedural errors or raise existing defenses, not to introduce new claims or recovery theories. So they're for correcting errors. A motion may be used to correct errors that have occurred during the process of the principal action. Motions can be used for affirmative defenses. A motion may be used to raise an affirmative defense, such as lack of jurisdiction, if it appears on the face of a prior pleading. It's not for new claims. A motion is not the proper place to raise a new claim or theory for recovery. And our practice tip here. In some circumstances, failure to include an affirmative defense in a motion may be a waiver of that defense, although a procedural rule governing waiver provisions may apply only to those motions enumerated in the rule. So you see what kind of motions, wow. So that's, check your jurisdiction regarding affirmative defenses in a motion. And here's our observation. In some jurisdictions, civil procedural rules applicable to special proceedings may not provide for any interlocutory motions except for motions to dismiss on points of law. So, civil procedure rules in some jurisdictions applicable to special proceedings, whichever those may be. Something to be aware of, though. And on we go to the repetitive motions. Courts may refuse to consider repetitive motions to prevent delay, but statutes and case law provide specific nuances on what constitutes impermissible repetition. So there's nuances, specific nuances. I don't know if that's an oxymoron or not. General rule. A court may refuse to consider repeated motions supported by substantially the same showing to prevent delay. Statutory limits. Statutes may limit parties' ability to file repetitive motions, so depending on the jurisdiction here. But the general rule is the court may refuse to consider repeated motions. Now here's a key, is substantially the same showing to prevent delay. The jurisdictional bar in some jurisdictions. A trial court lacks jurisdiction to entertain a successive post-judgment motion requesting the same or similar relief as the original. In some jurisdictions. And there's distinct motions. A motion for relief from a specific order and a later motion for relief from the denial of that motion are not impermissible successive motions when the order itself is subject to relief under the same rule. So there are times where there are distinct motions. An example given here is a motion for relief for the denial of the motion from a specific order. So this can be necessary at times to correct the errors. And here's a case example for repetitive motions. Motions based on the same legal theory may not be repetitive if they require the court to consider different evidence. Different evidence, same theory. A motion for summary judgment based on statutory immunity was not a repetitive motion, even after an unsuccessful motion to dismiss on the same basis. The reason for distinction. The motions were based on the same theory, but the court had to rely on different evidence. The motion to dismiss looked only at the complaint, while the summary judgment required the parties to designate evidence. So our observation here, statutes dealing with reconsideration of rulings may constitutionally limit the party's ability to file repetitive motions, but not the court's ability, on its own motion, to reconsider its prior interim orders so it may correct its own errors. Interesting. Very interesting example there, but there are certain statutes dealing with reconsideration of rulings. So that's something to look into in your jurisdiction. Now we're on to the joinder and splitting of motions. Omnibus motions seeking alternative relief are favored for efficiency, but splitting a single claim into multiple motions risks waiver. So omnibus motions, in some jurisdictions, these allow a party to move for relief in the alternative, combining different demands to save time and expense. They are authorized and favored where available. Then there's the hybrid motions, not favored in some jurisdictions. This example given here is combining a motion to dismiss with a motion for summary judgment. So that's something where a hybrid motion there. It's not combining different demands to save time and expense. Rule against splitting. A party may not divide objections or claims into several motions where complete relief can be granted in one. And then there's the waiver risk. Failure to raise an objection or claim that could and should have been included in a motion may waive that objection or claim. So the waiver risk, that's why it's important to ensure the motions include all the objections or, I guess, counterclaims here. Here's your observation. In some jurisdictions, so-called hybrid motions, which contain elements of several types of pretrial motions, are not favored. For example, a motion to dismiss may not be combined with a motion for summary judgment. See, that could be confusing indeed. All right, let's jump over here to the chat and see what we got going on here. All right, I hope everyone got the notifications. If so, please hit the like. Let's proceed. All right. Now we're on to persons who may make motions. While generally restricted to parties, non-parties can sometimes make motions. And strict rules govern joinder and procedural formalities. So the general rule is motions ordinarily can be made only by parties to the litigation. But in some circumstances, a non-party may be allowed to make a motion. The joinder for temporary orders. A joinder of all indispensable parties may not be required for a motion requesting a temporary order preserving existing rights. And then there's the oral joinder, which requires written confirmation to be formally part of the record. So we'll get more into that here. In the observation, even where affected by an order, a non-party may lack standing to proceed where the applicable statute provides that a motion may be brought by a party who is affected by an order. So, a non-party may lack standing to proceed where the applicable statute provides that a motion may be brought by a party who is affected by the order. Even where affected, that's an interesting observation there. So again, these statutory things can get very complicated and depends on the jurisdiction. Practice tip: when a party orally joins in on another party's motion, good practice demands that the motion be reduced to writing or that a simple written statement be lodged with the clerk evidencing such fact. And the resulting pleading must be filed forthwith and made part of the record. So that's your practice tip there. Even when a party orally joins in. At some point, it needs to, at the very least, be a simple written statement lodged with the clerk, evidencing such fact. And greetings, although the names aren't here on this channel for some reason, we just get the @ symbols, but hopefully that'll be corrected soon. I've seen it come and go on other channels. I think it's just a temporary modification from our YouTube stewards here. All right, so generally, the place for making the motions. The motions must follow procedural rules regarding where and how they are made, and they cannot be made within a brief. Wow, so the motions cannot be made in a brief. Purpose of the rules. The procedures are primarily intended to put parties on notice of claims sought by adverse parties. Court's limits. The court generally may not add conditions or prohibitions to procedural rules, but need not adhere to strict rules to determine if a motion was made. Wow, so not in a brief. As a general rule, motions may not be made in a brief. And a place prescribed. The place for making motions is generally prescribed by statute or court rule, often requiring it to be made in the county where the action is pending. Interesting. Especially in this day and age of electronic filings. We're on to section 9 here. Form and requisites of motions. So now we're on to our practice guide here. So this should get a little bit more practical for everyone. A motion must be a formal request that specifies its grounds and the relief sought with particularity to ensure fairness. So the formal requirement. As a general rule, some sort of formal motion must be made. Certification verification rules may apply to motions in some jurisdictions. Rule number. A rule may require the motion to state the rule number under which the movement is proceeding, but failure to do so is not necessarily fatal. And our observation here. Procedural and judicial administration rules governing the particularity requirement of a motion are designed to promote the policies of 1. Mitigating prejudice to opposing parties by allowing that party to respond to the motion. So that's one important reason there. And 2, assuring that a court can be apprised of the basis of the motion and rule upon it with a proper understanding. So those are the purpose for these governing the particularity requirement. So they need to be very particular so the court's apprised of the basis of the motion and the opposing party has its opportunity to respond effectively. We're on to the form and requisites of a motion. A motion must be a formal request that specifies its grounds and the relief sought with particularity to ensure fairness. The request for relief to be valid, a motion must include a request or demand for the relief sought. Particularity. A motion must specify the grounds and the relief sought with particularity to the particle, right? Our observation continued here. So this is coming on from this first one here with our 1 and 2, assuring the court can be apprised of the basis of the motion and rule upon it with proper understanding. Thus, under the law of some jurisdictions, the key issue to be resolved in determining the sufficiency of a motion is whether the document filed affords notice on the grounds and prayer of the motion to both the court and the opposing party, providing that party with a meaningful opportunity to respond, and the court with enough information to process the motion correctly. Makes perfect sense there. All right, let's continue on. So now we're on to professionalism and sufficiency. Very important one here. Motions must be professional in tone and can be saved by supporting papers, even if the motion itself is not perfectly specific. So, first of all, the professional tone. Motions should not contain irrelevant, disrespectful, or caustic remarks. A liberal reading. Nebulous language should be read in a manner most favorable to the moving party. So nebulous is like in the clouds. It should be read in a manner most favorable to the moving party. So the party filing the motion, the moving party, unless the motion totally fails to inform the court or opposing party. So nebulous language, as long as there's some substance to it, I guess, should be read in a manner most favorable to the moving party. Practice tip. A motion may be valid, even though it fails to meet the particularity requirement on its face, if supporting papers or briefs filed contemporaneous with the motion detail the grounds with specificity. So supporting papers like affidavits and other things like that, or briefs filed contemporaneously with the motion. So those are ways that a weak motion would not fail. It would still be valid. And the observation here is attorneys' motions should not contain irrelevant, disrespectful, and caustic remarks that only serve to vent a party's emotions, such as anger or hostility. And as we saw in the previous live stream on informal logic and ad hominems, that's clearly something that the courts should not be tolerating. Let's continue. We're continuing with professionalism and sufficiency. Motions must be professional in tone and can be saved by supporting papers, even if the motion itself is not perfectly specific. So again, we have the supporting papers. A motion may be valid, even if it fails to meet the particularity requirement on its face, if supporting papers filed with detail the grounds with specificity. And an amendment. A motion that is not sufficiently specific may be subject to amendment. So Am Jur likes to hammer these tones, as this redundancy is actually from the section there. The practice tip, though, continued. Let's go back here. This is a motion may be valid, though it fails to meet the particularity requirement on its face if supporting papers or briefs filed contemporaneous with the motion detail the grounds with specificity. Furthermore, a motion which is not sufficiently specific may be subject to amendment. So we saw here, you have supporting papers, or you could still be subject to amendment if they claim it's not sufficient. Our observation here continued. As we were saying before, the attorney's motions should not contain irrelevant, disrespectful, and caustic remarks that only serve to vent a party's emotions, such as anger or hostility. In this regard, venom, arrogance, and ad hominem attacks are not to be condoned in motions filed in the trial court, whether they are by a member of the practicing bar or a person acting pro se. So again, you treat as you want to be treated in that case, and the courts also respect that maxim. Let's proceed. When oral motions are proper, oral motions are appropriate when the court is actively hearing the case and no prejudice results from the informal procedure. During a trial, when a case is on the court calendar for trial, oral motions are in order. There's no per se rule. There is no absolute rule against oral motions if a proper evidentiary showing is made. Again, supporting evidence. From the record, an oral motion is permissible where the facts necessary to rule can be ascertained with reasonable certainty from the record. And there's pretrial motions. A court may entertain an oral pretrial motion when parties are before it and no prejudice would result. So the pretrial motions, oral motions, are proper. And there's supplementation. A written motion may be supplemented orally or informally and broadened in scope at the time it is presented. So it may be supplemented orally or informally and broadened in scope at the time it's presented. So yes, you could actually, I guess, almost be like amending your written motion orally at the time of the trial. Observation: a written motion may be supplemented orally or informally and may be broadened in scope at the time it is presented. And on we go. Section 10, motions as written or oral, part 2. The default rule is that motions must be in writing, But oral motions are permissible in specific court contexts, like trials or hearings. The purpose of writing: to guarantee the adverse party is informed of the motion's basis and to establish the time of filing. Writing fulfilled: the writing requirement may be fulfilled if the motion is stated in a written notice of the hearing. So our practice tip is continued here. A pro se litigant is held to the same standard as a licensed attorney in regard to writing requirements for motions. So there you go. Pro se litigants are held to the same standard. This was a long practice tip here. Have it divided up here. Furthermore, a motion which is not sufficiently specific may be subject to amendment. And we continued it here that a pro se litigant is held to the same standard as a licensed attorney in regard to writing requirements for motions. And I think the writing requirements meaning that the oral motions should be at least a written statement filed or lodged with the court. The observation here continued. For the similarly, under the federal rules of criminal procedure, a motion, except when made during a trial or hearing, must be in writing, unless the court permits the party to make the motion by other means. So the federal rules of criminal procedure, they're not going to tolerate these. That wouldn't be proper for an oral motion unless the court permits the party to make the motion by other means in writing. Interesting one there. And we're on to the signing of motion. Signing a motion is certification that the motion is not frivolous, is warranted by law, and has evidentiary support. Remember, it's not evidence, but it has evidentiary support, so it's not frivolous. The attorney's signature. Rules require every motion represented by an attorney be signed by that attorney. Federal rules. Attorneys and unrepresented parties in federal civil cases must sign every written motion. Certification of good faith. The signer certifies that the motion is not for an improper purpose, example given to harass, that legal contentions are warranted, and that factual contentions have or are likely to have evidentiary support. So, the factual contentions have or are likely to have evidence supporting them. And we're on to the notice of motion. Providing reasonable notice of a motion is a fundamental requirement of due process, ensuring the opposing party has a fair opportunity to respond. Right to notice. A party has a right to notice of a motion and an opportunity to be heard. There's the concept of fair play. The opportunity to receive notice and respond to a potentially dispositive motion is deeply embedded in the concept of fair play and justice. And then there's reasonable notice. Notice means reasonable notice, including a meaningful opportunity to prepare and defend. Who is entitled? Parties who have appeared in the action are generally entitled to notice. Notice to a non-appearing party may not be required unless new relief is sought against them. And there are sanctions. Sanctions may apply for failure to comply with applicable notice provisions. And our observation is, in some jurisdictions, a calendar request or notice of hearing need not accompany a valid motion. So check your local rules on that, and we're on to the effect of failure to give notice. An order made without proper notice may be void or voidable, but courts retain jurisdiction in certain circumstances where no prejudice is shown. Void or voidable order. Where notice is required, an order made on a motion without notice may be void or voidable. Court's jurisdiction. A court may still have jurisdiction to enter an order affecting a party who hasn't been given notice, particularly where lack of notice is not a jurisdictional defect. The non-moving party had actual notice and time to prepare, or the non-moving party was not otherwise prejudiced by the lack of notice. I think that was an and. Yes. All right. Service of motion papers. A motion is officially made So the motion is officially made when it is served. And strict rules govern how and when service must be completed. When a motion is made, the motion is made when the notice of motion is served. Service on party or attorney. Service on the adverse party or their attorney of record may be sufficient. Federal rules state that a written motion, except ex parte, and notice must be served on every party and service by mail. Statutes or rules may allow service by mail, which is deemed completed on the date of mailing in some jurisdictions, and the time for service, regulated by statute or rule, depending on residence and service method. Our practice tip here for service of motion in some jurisdictions: service of motion by mail is deemed completed on the date of mailing. So there it is. In some jurisdictions, service of motion by mail is deemed completed on the date of mailing. And a practice tip: in some jurisdictions, sanctions may apply for failure to comply with applicable notice and service provisions. So you get sanctions if you don't follow these service provisions here. And then there's the waiver. This is a nice one here. So pay attention to this tricky one. A party entitled to notice can waive that right, typically by engaging with the motion on its merits. So you think they can waive that right, like they're acknowledging, yes, I'm waiving that right, but they only do it by engaging with the motion on its merits. Waiver of notice. A party who is entitled to notice of motion may waive notice. Okay. Waiver of service. The requirement of service of motion papers may be waived where, for example, a party appears generally and resists the motion on its merits. So by acknowledging that motion and resisting it on the motion's merits and making a general appearance waives that requirement. Contesting service. Now, how do you get out of that trap there of waiving service if you don't intend to, but it's being done because, again, by resisting on the motion merits, you're engaging with the motion on its merits, and that's waiving the right in the eyes of the court. So how do you contest that? A respondent who wants to contest the validity of service must appear specially. They make a special appearance, and they ask to have the service set aside. You appear specially and ask the court to have the service set aside. Practice tip: party who appears generally and resists the motion on its merits is deemed to have waived the requirement of service of motion papers. So probably the best nugget of this whole presentation right there. Now we got filing and recording a motion. Filing a motion with the clerk is not enough. The moving party must actively bring the motion to the trial judge's attention for it to be heard. The date of filing. A motion is filed on the date it is received by the court and should be filed prior to a hearing. Duty to bring the court's attention. The party filing the motion has a duty to bring to the attention of the trial judge and request a hearing. So our practice tip: the party filing a motion has a duty to bring the motion to the attention of the trial judge and request a hearing on it. And unless the motion is brought to the trial court's attention and the court is requested to rule on it, the motion is not effectively made. So you've wasted time filing if you don't bring it to their attention. Filing a motion with a district clerk does not establish that the motion was brought to the attention of the trial court, because the clerk's knowledge of the motion is not imputed to the trial court. Wow. And the filing and recording of the motion. Filing a motion with the clerk is not enough. The moving party must actively bring the motion to the trial judge's attention for it to be heard. Filing is not enough. Filing with the clerk does not establish that the motion was brought to the trial court's attention, as the clerk's knowledge is not imputed to the judge. We just read this, but again, fax filing, that's why this is here. We can't forget about the fax filing. A motion may be filed by fax and deemed complete upon receipt by the clerk, provided the original and fees are forwarded within a set time. So if there's fees, they need to be forwarded too, because you can't forward the fees by fax. But a motion may be filed by fax and deemed complete upon receipt. Practice tip was continued. In this regard, as we were talking about, the party filing a motion has a duty to bring the attention of the trial judge, request a hearing. If not, the motion is not effectively made. In this regard, it has been said that the filing a motion with the district clerk does not establish that the motion was brought to the attention of the trial court, because the clerk's knowledge of the motion is not imputed to the trial court. How many times do we need to read that for this to stick in? But that's something that American jurisprudence wants to hammer in, and so we do. Despite the statements above, the view has sometimes been followed that a certificate of the clerk entered upon the paper at the time it is filed is the best evidence of filing. That's why we always want that stamped copy in your hand. That's best evidence. And we're on to the time for making or filing a motion. Motions must be made in a timely fashion as prescribed by rule or court order. Untimely or premature motions are generally ineffective. Premature or untimely motions are generally ineffective. Prescribed time is the time for making motions may be prescribed by statute or court rule, often within a certain period after a triggering event. So that's how we set our calendars. Untimely motion generally will be denied, unless the court grants an extension or excuses the untimeliness. Motion on eve of trial is generally too late, and a court does not abuse its discretion in denying it. So motion on the eve of trial, that's waiting too late. Got to get it in before then. Let's jump over here to the chat for a second here. Craig Carey is asking, can you bring the motion to court's attention and file at the same time? That would fall under, I think, oral motions. So if the court's willing to accept the oral motion and you're in that context, which probably wouldn't be a federal criminal case, then perhaps you could just bring it forth orally there, or even supplement a written motion orally at that time. And of course, it would have to be brought to the judge's attention, because the judge would have to permit it. So yes, the motion on eve of trial is generally too late, though, to file this. This is about filing the motion. And a court does not abuse its discretion in denying it. And then there's the premature motion. So even if it's premature, it has the same effect as one filed too late. It is not procedurally effective. And then there's the rationale, based on public policy of orderly procedure, speedy justice, and the doctrine of finality of judgments. So there's a rationale for the filing in a timely fashion. And our practice tip, the timeliness of a motion generally must be determined by the timetables in effect when the motion was filed. It may be measured as of the date the motion was filed in the clerk's office, rather than when it was mailed, depending on your jurisdiction. And we're on to premature motions and filing dates. A prematurely filed motion is generally ineffective, but courts may treat it as timely if clerical delays or prior court indications justify it. Premature filing. Generally, a prematurely filed motion will not ripen into a properly filed one and may be denied. Court's indication. A motion may be timely even if made before an order is entered, if the court has previously indicated what order it will make. When they do that, a clerk's delay, a post-judgment motion filed before the judgment was entered due to the clerk's failure to enter it, may be treated as timely. And the date of tender. In determining timeliness, the date the instrument is tendered to the trial clerk controls the file stamp. So the instrument is tendered. That's going to be a satisfaction of something there, right? All right, let's move along. Allowance of untimely motions. Courts have broad discretion to allow untimely motions, as they do to deny it too, it seems, often based on a showing of good cause or excusable neglect, where no prejudice exists. But that's up to the court's discretion. Court ordinarily has broad discretion to allow untimely motions and grant extensions of time, and it's not jurisdictional. Failure to comply with a time period is not jurisdictional, though it may be enforced if prejudice is shown. So our observation is, while as a rule the trial court's discretionary power to hear an untimely motion may be exercised, and prior exercise may be corrected, as sound discretion may require, at any time prior to final judgment, some jurisdictions have limited the length of a discretionary extension of time to file a motion. So, seems like there's a lot of difference between jurisdictions and if there's statutes allowing the trial court's discretion. Bill Thomas says, I heard that early is on time and on time is late, and late's not that great. Yeah, I mean, well, as we see here, if it's too early, then it could be considered ineffective too. It has to have a reason to be early. So, yeah, it could all depend. Now we're on to the allowance of untimely motions. Courts have broad discretion to allow untimely motions, often based on a showing of good cause. You saw this, right? Okay, yeah. Good cause, the litigant's failure to file timely is not fatal if they can establish good cause for the delay. This is a question of fact for the trial court. Oh, wow, fact. So you can't just have a letter saying that. You could have some fact. Dispositive motions. A party's reference for raising a dispositive issue in a motion in limine does not constitute good cause for a belated dispositive motion. Oh, wow. So it's an issue in motion in limine. Oh, wow. So it's, yeah, timing of that stuff. Who gets in their motions first? Wow. All right, a practical application. And a motion in limine is something to keep evidence from being before the court and being considered. All right, so we have practical application. The courts balance the need for procedural efficiency with the principle that substantive justice should not be sacrificed for technicalities when determining whether to allow untimely motions. So substantive justice, this is a key one there for the good cause, and it shouldn't be sacrificed for technicalities in determining whether to allow untimely motions. Again, it's to the court's discretion, but they need to balance that need for procedural efficiency and principle. All right, we're on excusable neglect. Excusable neglect is a narrow standard for extending time to file a motion. It does not include simple mistakes or ignorance of the rules. A standard for extension. A motion for extension of time may be based on excusable neglect, which should be applied liberally to work substantial justice. What is not excusable? Excusable neglect has been said not to include inadvertence or mistake of counsel or ignorance of the rules. Ignorance of the law is inexcusable. Practice tip. In some jurisdictions, a party seeking an enlargement of time for filing a motion must file the request for extension before the initial filing deadline. When the party misses that deadline, the party must file a request to allow the late filing, setting forth an explanation of why the untimely filing resulted from an excusable neglect. Ooh, boy. So get it excused before you get the past the deadline. Word to the wise. All right, and we're on to excusable neglect, part 2. It's a narrow standard for extending time to file a motion. It does not include simple mistakes or ignorance of the rules. Discretionary. A motion for extension based on excusable neglect is addressed to the trial court's sound discretion and will not be set aside on appeal absent an abuse of that discretion. It has limited application. Such a statute has been held not to apply to certain types of motions. So our practice tip continued in this regard. I love this, how they do as well. So some jurisdictions, right, the the party must file a request to allow the late filing first. So that's why you don't want to miss the deadlines. In this regard, while it is surely within a trial court's discretion to grant a timely motion to enlarge, even after the period to be enlarged has expired, the court's failure to do so, or for that matter, its failure to take action on the motion at all, does not automatically extend an existing filing deadline. So, again, best just to keep with the deadlines. And we're on to the amendment of motion. Trial judge has broad discretion to allow the amendments to motions, but cannot expand a dispositive motion in a way that unfairly surprises or prejudices the other party. Wow. There's broad discretion. A trial judge has broad discretion in allowing amendments to the motions and wide latitude in the manner allowing them, such as orally. Limitation on dispositive motions. A court generally may not alter or expand a dispositive motion without taking adequate steps to avoid the unfair surprise or the prejudice. So no surprises there. And of course, limitations on the dispositive motions, and then the timeliness. An application for leave to amend must generally be timely and may be denied if it fails to disclose merit or is defectively verified. So no facts, you don't have any truth to it, and it's just there, it seems, as a frivolous filing, then an application for leave to amend may be denied. Relation back. Amended motions substitute for and relate back in time to the motions they amend, if they do not pertain to a wholly new matter. So there's a relation back in the amendments. And again, the judge, this is broad discretion in allowing these things. And the effect of filing. When an amended motion is filed, the original is eliminated, and only the new motion will be considered. Now, this is a critical aspect of amended motions. When an amended motion is filed, the original is eliminated, and only the new motion will be considered. So if you had filed an amended motion, went to the hearing, and it was filed timely, it was filed and accepted, brought to the attention of the judge, so they have knowledge of it, yet it was never litigated, it was the original being litigated, then that's a procedural error. And that would be an appealable, I believe, under review. So the original is eliminated, and only the new motion will be considered. And only. So it's not even a supplement. An amended motion would be totally replacing the original, because the original would be eliminated. Interesting concept there. And we're on to the motion papers generally. The motion papers define the scope of the request, and a court will not grant relief on grounds not included in those papers. They define the scope, the papers. Definition of motion papers may include the motion itself, a notice of motion, supporting affidavits, which would be some evidence, or a memorandum of points and authorities. It also includes other documents attached or incorporated by reference. Could be judicial notice too, I believe. Scope of consideration. Court ordinarily will not consider or grant a motion on grounds not urged in the motion papers. So the particularity, the brief deadlines. The filing of subsequent motion does not automatically defer the deadline for filing a brief on a prior motion. So deadlines don't change by filing subsequent motions. Proposed amendments. The failure to attach a proposed amendment to a motion for leave to amend is not necessarily fatal, but a court may deny leave if it cannot evaluate the proposed change. Here's a practice tip. A court ordinarily will not consider or grant a motion on grounds not urged in the motion papers. So asking for something that wasn't on the motion papers is typically not granted there. not ordinarily. And our observation, the filing of subsequent motion does not automatically defer the deadline for filing a brief on a prior motion. A brief must be tendered when due. All right, and that brings us to the conclusion. Mastering motion practice. Effective motion practice balances strict procedural compliance with the court's discretionary power, all in service of a fair and efficient judicial process. So let's go over our summary of the core principles. Motions are procedural tools. They're designed to manage an existing case, not initiate new litigation or introduce entirely new claims for recovery. Due process is foundational. The entire framework of notice, service, and an opportunity to be heard is a non-negotiable requirement to ensure fairness and prevent prejudice. Rules and discretion coexist. While courts have broad discretion to interpret rules and prevent injustice, parties must adhere strictly to requirements for form, timing, and particularity to avoid waiver or dismissal. And our tiny one here is precision and professionalism are paramount. Success depends on clearly stating the grounds and relief sought, maintaining a professional tone, and ensuring all arguments are supported by the motion papers themselves. And our final thought for tonight. Ultimately, mastering motion practice serves the interest of justice by promoting clarity, efficiency, and fairness for all parties and the court. So with that, I'd like to thank you all for attending the Motions, Law, and Procedure from American Jurisprudence. I learned a lot of new nuances, I guess you could say in here, specific nuances as they call them, but definitely some handy little practice tips that it's always little gems you find in American jurisprudence and why it's such a great piece of our American legal heritage here. And it keeps things, I guess, on the most straight and narrow path we can for any other judicial system. That said, it's up to us to ensure these principles are upheld, and that's why I like to go over these, and I appreciate everyone here. I know there's a lot of other things to view on YouTube, but this is something where, when we really walk away with something you can apply, it's I hope it does bring some value. That said, thank you all for coming. Yeah, the devil is in the details or in the nuances, but then why do acts of God always require a lot of destruction and no fault? So, a lot of twisting of words in the way they're actually the outcome is. The details actually do matter. And yes, you're very welcome, and I thank you all for coming here, and I hope to see you all on the next one. Peace out.